So good afternoon and welcome to this Northamptonshire CIPD branch event. It's in partnership with our neighbours at Leicestershire, I believe, as well. And it's an employment law update with our guest speakers from House Percival. Next slide, Eleanor. So connect with us online. You've got two different addresses, cipd.co.uk, either Leicester or Northampton, but you could join both. That's absolutely not a problem. And we've got LinkedIn groups as well for both Leicestershire branch and Northampton branch. And again, the Twitter handles are there as well on the bottom of the screen. Next screen. So help us to run a successful webinar. Please note your microphone will be on mute throughout the session. You can use the chat box to introduce yourself and make comments, but because this is a webinar function, use the question and answer section, which will be in the bottom band at the bottom, to raise specific questions for our guest speakers. The slides and the recordings will be circulated via email after the event. And as always with our CIPD events, it's really important if you could complete our Survey Monkey, because it's really important that we get your feedback, because that helps us think about the events that you like and what we need to put on for you to help your learning and continued CPD. Please use your full name in the participant list. So future events, so in Northamptonshire, we've got the HR Independence Group meeting, how to get those sales, one of our least favourite topic, I think, for HR consultants. So we've got a guest speaker joining us on Thursday, the 21st of October. Leicestershire branch, they've got Advancing Fairness at Work with a guest speaker, Louise Lennon from the People Deal. And that event is online on Wednesday, the 27th. And then also Leicestershire, their HR Independence Group meeting, they're at the Fieldhead Hotel on Friday, the 12th of November. Got the Midlands L&D event, Leading Change Through Learning and Development, and that's an online event on the evening of Tuesday, 23rd of November. And then Diversity and Inclusion Group, they're online on Wednesday, the 15th of December, nearly time for Christmas. So book your place online at cipd.co.uk, Leicester, or CIPD UK Northampton. Just some benefits about the CIPD. I'm obviously aware that some people, we're all losing the perk box membership, but there is other benefits as well that you can see. There's just some things on there, and you can go online to look at the member benefits as being part of a CIPD. And again, this is why we encourage the feedback, so that we make sure that you're getting some of the events that you really would want us to put on for you. So with no further ado, I'm going to hand over to Graham Irons and the team at House Percival with the employment law update.
Thank you. Well, good afternoon, everybody. I would say nice to see you, but as you know, with the webinar, I can't see anybody at all. By contrast, this morning, we did do our first in-person seminar at our offices in our seminar room. And we had just under 20 people there. So we restricted the number for our trial events with the CIPD. And it was lovely. It was so nice to see everybody and to deliver the seminar in person. So sorry we can't do that for you today, but you'll get the same information, but via Zoom instead. So hope you enjoy it today. The next slide, please. So your speakers, as you can see there, myself, Graham Irons, partner, my fellow partner, Simon DeMay there.
Afternoon.
Next slide, please. And we've also got Hannah Price, one of our directors in the team, and Sobia Ahmed, who is an associate in the team. So that's your speakers today. So I'll be kicking off. So what are we going to cover today? When we started planning this seminar, we said, oh, I don't know, is there much happening? And often there's sort of maybe new legislation or loads of cases. There wasn't so many cases this time, strangely. So there wasn't that many cases. We've still got 4 really interesting cases to talk to you about today. But there was various other bits of interest, and we're going to cover those for you over the next hour. So the government consultation was taking place on sexual harassment in response to that. So I'll be talking to you about that. There's a usual increase to the Vento bans on injury to feelings awards. So I'll be talking to you about that and giving you some interesting examples of that one. Gender pay gap reporting, just a reminder on that one. As you can see, Simon will then take over to talk about right to work checks, mandatory vaccinations, long COVID, flexible apprenticeships, 4-day working week for everybody, but only if you're in Scotland, flexible working, tipping. We will accept tips, by the way, after this if you're happy with the performance. And what's on the horizon is the last thing. So, and then finally, as always, we have our case law quiz. So we'll hand over to Sobia and Hannah, and we've got 4 cases there to test your knowledge and see what you think about. See what the court, the judges and the tribunals may have decided. And in answer to a question that's just popped up, yes, you will get a copy of the slides sent to you after this event. Okay, so sexual harassment. So the government carried out a consultation exercise off the back, really, of the Me Too campaign to look at sexual harassment, which has been seen as a significant issue across the employment. So they responded to that consultation on the 21st of July. And it's the key elements we've got here: introducing a duty to require employees to prevent sexual harassment. I'll be talking more about these elements soon, by the way. Introduce explicit protection for third-party harassment. Then, in relation to the idea of extended protection to volunteers and interns, what they said was that many interns are already protected. Now, if they are genuinely doing internship as part of some sort of college course, having a few weeks of unpaid work, then that would clearly be a proper intern. Whereas if they are someone that an employer's taking advantage and they're just working full time for no pay and labeling it as an internship, then they're probably already a worker, is what the consultation said, and therefore they do have rights under the Equality Act for that reason. In terms of volunteers, they're not going to extend protection to volunteers. There has been case law before that said volunteers aren't covered by the Equality Act, and they're not going to extend protection. The reason for that is because they don't want to put too much red tape in that sector. There's people volunteering in so many different ways, and the concern was if there's some liability there in respect of harassment, then that might put people off volunteering. It's got too much red tape. So that's that one. Lastly, they're looking at extending the time for bringing sexual harassment claims. I don't know whether this will happen or not. It's only being considered. So unlike a couple of the other bits above, they have clearly stated they're going to introduce those things like the duty to prevent and the third-party harassment protection. They haven't said for certain. So why might they want a longer period? The key reason for that will be the fact that often it's kind of traumatic experience to obviously go through sexual harassment, and people want time to recover, and also they want time to take stock about what they want to do. The big problem with being a tribunal claim for something like sexual harassment is you've got to go through it all again. Not everyone wants to do that, not surprisingly. So if you've got to do a statement detailing what's happened to you, you then got to face the prospect of cross-examination about what's happened to you again in the tribunal. You know, with tribunal hearings now could be listed a year away. You've got it hanging over you for potentially a year or more. So there's lots of things to think about for someone bringing a sexual harassment case. So that's the sort of logic behind it. The flip side to this is, and the concern that has been raised in the consultation, is memories fade. And if you leave the time, if you double the time limit to 6 months, that's a concern. I mean, I personally think the bigger concern is actually the delays in the tribunal, but it is a concern. And with harassment cases, particularly, they're very, very sensitive in terms of what was said, how it was said, that sort of thing. So the closer someone records that in their claim form, for example, to the actual events, the more likely it is you're going to be able to have an accurate recollection. And similarly, for the employer responding with their witnesses, once they understand the claim being brought, they can get to witnesses quicker while their memories are still fresh. So wait and see on that one. Can the next slide, please? So the duty requiring employers to prevent sexual harassment is a positive duty. So we do have already the reasonable steps defence for employers. So if they are facing a discrimination claim, for certain claims, they can say they took all, like harassment, they can say they took all reasonable steps to prevent discrimination happening. How would they do that? Clearly things like we've got an equal ops policy, we've got a harassment policy, we've given training to all staff and to managers. We're going through those sort of things to a tribunal, and that can help, that can provide defence. And if that defence is successful, we can end up in a situation where the individual harasser is liable, but the employer is not liable. So that's how that works. It's not an easy defence. You have got to do quite a bit, as you can imagine. It will make sense. So there was a case I probably talked to this forum before about a few years ago, involving a car sales showroom, and the employer tried to rely on the defence in that case. It was all about making lewd remarks to a female sales manager, and questioning her about her sex life with a boyfriend and things like this. So, and they tried to argue that they had taken all reasonable steps. They pointed to an equal opportunities policy. They pointed to some training. But even then, the employment tribunal said that's all very well, but it's quite clear from the evidence there is a culture of sexism here that you're not only allowing, you're perpetuating through the conduct of management, and therefore the reasonable steps defence fails. So we may be looking essentially at something around a reasonable steps. We don't know what those steps are going to be, but either way, it's a positive duty to prevent. So how might that work in terms of enforcement? And that was part of the consultation too. The first question that was asked was, do you have to bring a claim to have an employer face potential liability for breach of duty? And they've answered that, the government have answered that to say yes, there will have to be a claim. So it's not just a question of somebody whistleblowing on their employer, they're not doing enough. They've actually got to be an actual claim of sexual harassment. So that's the first thing. The second thing is, well, how do you compensate that? Because for discrimination claims, you already compensate for loss of earnings and for injury to feelings, which we'll be talking about later. So on that one possible idea is to follow the protective awards that are used, or that style of award for CIPD. So if there's a failure to inform or consult, as you'll be aware, the remedy is up to 13 weeks pay per employee. So they could take a similar approach to that in respect of awarding compensation for the breach of this duty. So we're yet to see how that's going to work. We have had guidance through the Equality and Human Rights Commission. So January last year, they produced a pretty hefty tome, about 65 pages, going through issues around sexual harassment, giving some good examples of sexual harassment and how to deal with it, and including some steps that could be taken to help prevent it, which I've actually bullet pointed at the bottom of this slide. And they call that their technical guidance. So useful document if you're looking at this kind of area. So that may give a clue, but they also talk about bringing out some further guidance to help employers put themselves in a position where they can take the appropriate steps to prevent sexual harassment. So in the meantime, as I say, there are these core points here that come out of the guidance I've just listed. So effective policies and procedures. Obvious starting point for all HR practitioners. So what the guidance talks about, interesting, is having a separate sexual harassment policy. I don't think that many employers will do that. Instead, they'll have a part of their general anti-harassment policy that would deal with that area. It's just worth bearing in mind that there are some very specific issues for sexual harassment that need to be considered, and certainly under the Quality Act, there are some specific provisions that basically set out some slightly different types of harassment than for the other protected characteristics. For example, one of the provisions deals with being subjected to a detriment where you've spurned unwanted advances. So something very specific to sexual harassment. So that's something that you should make sure you're covering off if you have got a general anti-harassment policy. And just make sure you've got that you're clearly dealing with all the relevant parts of sexual harassment in the policy. Obviously, you've got to communicate that policy and train people on it. I mean, picking up training. Training is obviously fundamentally important. Having a policy sitting on the intranet or embedded in a handbook, it doesn't really take you that far. So training is really important. At House Percival, we're actually just doing some bullying, anti-bullying and harassment training ourselves. So we're getting an external speaker who's going to talk about her experience of being bullied in the workplace as part one of our training, and part two then it's going to be delivered by some members of our employment team, including Hannah Price. So she'll be delivering that to all staff. More practical issues around sexual harassment, and of course talking about our policy and procedures and reporting. So important steps there to take into the training. If you need some help on training, we are very happy to do that. Give you some help on that. So do let us know if that's of interest. In terms of staff engagement, this kind of comes back to the point I mentioned about that car showroom case. It's all very well having all the paperwork and saying you've trained, but if actually your culture is the complete opposite of that, and it allows and encourages sexual harassment, then clearly you're going to be letting yourself down very badly. So that's a really important thing to embed, as well as the policies and the training. Risk assessment, that seems a slightly odd one, doesn't it? But what the guidance says, and it's a really interesting point, I think, is it's about risk assessing how people work, where people work, who they work with, and for example, lone workers or people or whether a couple of people just have to work together, man and woman in a confined area. So that sort of thing is actually quite an interesting idea doing the risk assessment, and it's something I think is well worth considering. And it may be it gets embedded in this duty to prevent sexual harassment. So that's worth considering. But I had a case a few years ago where I was acting for a female employee who had been harassed by her manager. And that was a situation where, thinking of the idea of the risk assessment, they were salespeople and they were staying over at a hotel. There was an event going on there, both of that event. So they stayed at the hotel. There was a apparent mix-up with the rooms. The result of that mix-up was that the manager had both the keys to his own room and the keys to my client's room. So having gone out for an evening of food and drink, she went to bed early. And then she awoke to find the manager standing at the end of her bed, taking his trousers off. So obviously, a serious issue. Ultimately, we sort of took them to tribunal, but we managed to get that settled for her to save her all the aggravation of the tribunal process. Those. It's about, I think, the risk assessment side. It's about narrowing the window of opportunity, understanding where opportunity might lie for the would-be harasser, and trying to close the door on it. So on to reporting. That's obviously very important because people need to feel comfortable to be able to report harassment and understand very clearly who they're going to report it to, because it can be a very big decision to report sexual harassment because of the serious nature of it, the impact it'll have on working relationships, and potentially the embarrassment, because people will feel, have I done something to encourage this? They'll be worried about that sort of thing as well. They're worried about the implications for them if the person's more senior to them. Are they basically open themselves up to issues around being treated detrimentally, for example, or being ousted from the business? So it's a bit of a critical one, reporting. So obviously there are clear channels such as HR, which is fine. There may be dedicated people. Some people train people up specifically to to be able to deal with sexual harassment issues, so they can deal with it in a sensitive and sensible way. And the guidance itself talked about the possibility of having some sort of external service that people can raise sexual harassment issues with. So that's another idea there. So, but yeah, really fundamentally important in enabling people to raise it and then give you a chance to deal with it. Next slide, please. Third-party harassment. So we've seen this before. Many of you may remember this. So the starting point, I guess, was a case involved with Bernard Manning. If you don't know who Bernard Manning is because you're not old enough, then Bernard Manning was supposedly a comedian. If you think sexist and racist humor is acceptable. So that was his brand of humor, and very, very well-known comedian, in inverted speech marks. And he was doing there was a business dinner at a De Vere hotel. He was the guest speaker. There were 2 black waitresses on duty that night, and he was making sexist and racist jokes, some directed at them. And then it got worse because some of the guests decided that as a hilarious idea, and they would also make some jokes at the waitress's expense. That's a situation we had. So not surprisingly, the waitresses tried to bring sexual harassment claims, and I think there's racial discrimination claims too, against De Vere hotels, and ultimately they succeeded, and it was found to be that the situation was in the control of De Vere hotels, and therefore they were liable for the discrimination. Clearly, they could have done something about it, because they could have understood that because of the person who was speaking, perhaps they shouldn't have had them on duty in the first place, or when it became apparent there was an issue, they could have been moved off duty at that stage. So it was within their control. So Section 40 of the Equality Act, when that first came into force, tried to address this, put it on the statute book rather than rely on case law. And they came up with this 3 strikes rule. So the idea was, employee gets harassed by a third party, let's say a customer, and you don't do anything about it as an employer, not an issue. Happens again, okay, doesn't matter, you're still not liable for it. If it happens a third time, then at that point, essentially you are liable for the discrimination. The slightly odd thing about the wording of Section 40 was that it didn't have to be the same third party. So that I never understood that. It didn't really make any sense. I mean, let's face it. I mean, okay, you'd hope you'd be pretty unlucky to be harassed by 3 different third parties. But even so, it's a strange rule. So anyway, it was repealed in 2013, so some time ago now, and the government is looking to bring that back into play, which I think is absolutely right. But what they are going to bring in is an all reasonable steps defence. So which we already talked about on the previous slide. So they are going to give some guidance on this, and as you can see from that slide in the bullet point there, they're looking to try and avoid a sort of a tick box exercise they could rely on, but look at proportionality and flexibility in terms of giving an opportunity for employers to argue they've tried to manage the harassment in the first place. So clearly, employers should have anyway a zero tolerance approach on sexual harassment or other harassment from anybody, whether it's employees or third parties. And there will be situations where things arise where, for example, a customer crosses the line, either inadvertently or deliberately, and clearly employers should be dealing with that. So make sure you do cover that in your harassment policy and procedures. As a matter of course, regardless really of whether this comes into force. Okay, next slide, please. So what happens actually if it does go wrong and there is a finding of harassment? Well, we get into compensation. So Vento bands, as you may recall, these are the different bands for injury to fillings awards. and they get increased every year. So you can see they're only slightly increased this year. So you can see for the lower band, it's £900 to £9,000. And that's going up to £9,100 at the higher end. For the middle band, we've got 9,000, 27,000, and it's going up to £27,400. And then the top band, so the most serious stuff, that's going to from 27,000 to 27,400, and then up to 45,600. There can be awards in excess of the 45,600, but they're going to be pretty exceptional cases. So injury to feelings is awarded regardless of financial loss. So someone can walk straight into another job, but there is still a risk of them bringing a claim for just to get injury to feelings awards. So we tend to say if someone was dismissed and it's discriminatory, then you're probably looking at the middle band for a discriminatory dismissal. If it's a one-off comment, you're probably looking at the lower band, and a serious campaign of harassment, look at the most serious, the high level band. So I've got a few examples I thought would be useful to give you some colour to this, really. Upper band, you had someone who's an admin officer at the Department for Work and Pensions, based in Caerphilly. And so she would describe herself as being of Nigerian Welsh origin, and she was 55 years old. And she was out of the group of new recruits. She was the only one who was over 50, and she was the only one who wasn't white. It seemed as a result of this that she, unfortunately, she was picked on and bullied. She'd confided in one of the individuals, because there's a particular person who was bullying her most. She confided in one of the individuals about this person and told them not to say anything. So what did they do? They went and told the individual straight away what she told them. So she found it really difficult to complete the training. She went on sick leave. She raised a grievance. She went off with stress at work, and then they overpaid her on sick pay. So bizarrely, they then end up sending around debt collectors to her to try and to reclaim the money. So she brought tribunal claims for all these things. And by the way, all the other trainees in the group were retained, and she was the only one who wasn't. So she ultimately got awarded £35,000 for injury to feelings. She also got £7,500 for what we call aggravated damages. And so that's where essentially the employer sort of rubs salt in the wound or behaved in a particularly reprehensible way, and maybe something like the sending the debt collectors around, which is slightly unusual, would have been something that contributed towards that. She ended up with a financial loss, by the way, of over £200,000, and because the tribunal accepted, she was likely to really struggle to get another job for some long time. So that was that one. That's the upper band. The middle band, that one. Well, that one, we've got a medical secretary who worked for the Royal Berkshire NHS Foundation Trust, and the thing that moves me most about this, she was 87 years old when she was dismissed. 87, still going at 87, which is incredible. So, which made these events even more sad, really, because she changed from being a secretary. They asked her to become a patient pathway coordinator, and then she was told she wasn't doing the job properly, but she wasn't getting proper training. She said she had her colleagues talking about her as being stuck in her old secretarial ways, referring to her age and being frail. And she raised a grievance, but it never got properly dealt with. She subsequently got dismissed for poor performance. She appealed, but for some bizarre reason, the trust refused to allow her to have an appeal. Don't know why. So ultimately, she succeeded in complaints not only of age discrimination, but also of disability discrimination and unfair dismissal. And she got £20,000 injury to feelings for that. The last one is a slightly odd case, actually, from 2019. Mr. Rawnsley brought a claim. He was a factory operative, 20 years old, and he had a bit of a complaint to make, so he spoke to his managing director about it. It all got a bit heated, and the managing director ended up sort of pushing his face, striking his face and pushing him away. He obviously thought that wasn't the ideal thing to do to your employee. So as a result of that, he then sent him a nice apology letter. Unfortunately, within that letter, he did say to him that he was a jumped up, know-it-all, spoilt child. So not the best apology, you might think. So as a result of that, Mr. Rawnsley brought a tribunal claim and said it was age discrimination, obviously the reference to a child, him being over 20. The tribunal did accept that was a discrimination. And as a result of that, he got awarded £1,000. So I say that sort of that's probably about right. Maybe should be a little bit higher. But interestingly, he wasn't able to show that being assaulted was age discrimination. And there's a good reason for that. And that was because it was accepted evidence that the MD had regularly lost his temper with lots of other employees too. So he wasn't picking on him because of his age. So that gives you a bit of flavour there for how these Vento bans work in practice. They're very difficult to call, is what I would say. We often make representations to try and refer to other cases, but they're very fact sensitive. So not very easy to really properly guess where you might land on these things. And then part of that's because the impact on every individual is different. So some people end up having a complete breakdown from discrimination, and others sort of, whilst it's not very pleasant, shrug it off and just go into another job. So all those sort of things can impact on injury to feelings. Next slide, please. Gender pay gap reporting. So the reporting deadline was extended to the 5th of October. In fact, I think the deadline stayed the same, but what the Equality and Human Rights Commission said was we won't enforce until the 5th of October. What does enforcement mean? It means them saying, you haven't done it, can you make sure you do it? They might get a court order to do that if you really don't do it. And then if you breach that court order, then that could potentially mean compensation. Or a penalty rather. Unusual step to take. And of course, naming and shaming is the other thing that happens with failure to report a gender pay gap. So the previous years was extended from April through to October. We haven't heard for the following year, but the assumption is that it will revert to the 31st of March for the public sector to report, and the 5th of April for the private sector to report on their gender pay gaps. So that's it for my section, and I'm now going to hand over to Simon.
Good afternoon, everyone. Thank you, Graham. I would say it's nice to see you all, but like Graham, I'm just staring at a blank screen, looking back at myself and the slides. Anyway, I'm glad to see there's 150 or so of you on the screen today. Thanks for coming. So as Graham mentioned, there are quite a few things to get through, but some of these are more about touch points or just keeping you up to speed with what's going on. And a lot of it doesn't need to be too in-depth. This might be one of those. So the first slide is about right to work checks. So if you remember, I'm sure if you have to do them, you'll recall there's a COVID-19 concession in relation to right to work checks. That's going to cease on the 5th of April next year. So at the moment, the concession will allow you to carry out right to work checks by video call, by mobile app, or by email. But from the 5th of April next year, you need to revert to doing the full normal right to work checks in the usual way. So that means checking an applicant's original documents, doing that in person. So seeing the documents and seeing that person. You will be able to do right to work online checks for those holding biometric residence permits or holding status under the EU settlement scheme. And if you can't check if it's not possible to check the documentation in person, the applicant can post you the documents or get them to you in transit so that you've got the original documents, but you then conduct a live video call with the applicant. So that's going to be reverting to type from 5th of April next year. Probably stating the obvious, but just as a reminder, you won't need to carry out any retrospective checks. So any employees that were hired using the adjusted check, you don't have to retrospectively do the correct check as long as you did it in the prescribed manner at the time. So that's it on right to work checks. The next slide will talk a little bit about mandatory vaccines. So this is an interesting one, and I appreciate there's 150 people on here, and of you, I suspect perhaps no more than one or two work in the care sector and will actually, these regulations will be relevant to you, but they're really, really interesting anyway for a number of factors. But on the back of what happened during the pandemic to care homes in particular, the government rushed through some legislation in July this year, and the new laws, it doesn't say it on the slide, but the new laws come into force on the 11th of November. What that means is from the 11th of November onwards, care homes can't admit anyone, including their own employees, into the care home unless they can provide evidence of being fully vaccinated. So what that's meant in practice, absolute carnage for those running care homes, frankly, is that it's been an administrative nightmare, because employers have had to almost overnight start to collate data from their employees, which is not an easy thing to do in relation to their vaccination status. What employers have had to say to their employees is that we need to know that you're fully vaccinated by the 11th of November. You can either produce that evidence now, or you can produce evidence to say that you've at least had your first dose of the vaccine by the 16th of September, because then that would allow you to have your second dose within an 8-week period, which will be up to the 10th of November. And so care homes have really had to start taking steps quite early on to consult with their employees with a view to understanding their vaccine status, but also consulting with a view to dismissing those who are reluctant to take the vaccine. And it's been a real problem, because you can imagine interviewing employees about where's your vaccine status, and some will say, sorry, I've forgotten it. Some will say, well, I've had my first one, but I haven't got the evidence yet. Or some will say, I've got the second lined up. Some will say that I'm not going to have it, at which point you're then talking about dismissing them. But of course, dismissal would be for either illegality or some other substantial reason. So that's been interesting on its own. But because of the tight timeframes in which the government have asked care homes to operate, it means that it's been impossible to give some employees, say, if you're on 3 months' notice to terminate on or before the 11th of November, because the timeframe is so tight, which means that care homes will be employing staff who aren't allowed to walk through the front door after the 11th of November. And one of the questions that has come up is whether or not care homes should still pay their staff. Staff will argue, well, I'm ready, willing and able to come to work, and the care home will say, well, that's all good and well, but it's illegal to allow you to cross the threshold. So it's been a real problem, and what we've been advising clients is actually, it's probably a technical argument that employees should be paid, but if they are still employed after the 11th of November and they've refused to have the vaccine, then I think employers are within their rights to withhold that pay. Now, there are some exemptions, medical exemptions being one, or exemptions for staff who are under the age of 18, but the medical exemption has been a bit of a disaster, frankly, because the government was supposed to amend the COVID pass to enable employees to effectively get a stamp in their pass with a medical exemption. But there was a huge delay in doing that, which meant instead the government, right at the last minute, allowed employees to self-certify their medical exemption status. So all an employee has to do is complete a form produced by the government to say that they're medically exempt. What that gives them then is 12 weeks grace from when the COVID pass comes in. The COVID pass then came in completely unannounced on the 1st of October. So the 12 weeks grace that these self-certifiers have will expire on Christmas Eve. So the bad news for them will be if they haven't got their exemption, happy Christmas, you'll be dismissed on Christmas Eve if you haven't got your proper COVID pass in place. So this has been hugely disruptive to the care sector. It's come at a terrible time when we're kind of getting into autumn and winter, and we need more care staff to look after vulnerable people. Unfortunately, there will be a loss of maybe 70,000 to 120,000 care staff from that sector. Some of them will go into other sectors. Some of them will go and work in the NHS. So there is a certain amount of irony there, because they will be looking after vulnerable people in any event, but they won't have the vaccination. Now, on that particular point, there was a consultation launched on the 9th of September. It's a 6-week consultation as to whether or not there should be compulsory COVID jabs for frontline NHS staff and care workers. So there's a government consultation. The consultation ends on Friday next week. I know the government had previously stated there would be no plans to extend mandatory vaccination beyond health and care workers, but I would say watch this space. I don't know, it's a bit of a political hot potato. I think we have to see what's going on with the increase in the infection rate. We were at about 42,000 per day as of yesterday, I think. So I don't know whether the NHS could afford to start going into mandatory vaccinations now or at any point in the winter. We do have, as a result of the infection rate going up, we do have a few client inquiries about whether or not mandatory vaccination is something that they could introduce to their workforce. I'll probably come at it from two angles. One is with new recruits, I suspect it's quite easy to introduce a mandatory vaccination for anybody that you're bringing onto your books for the first time, because you just build it into the interview process, you build it into their contract. And I think there's probably negligible risk of a discrimination claim. And indirect discrimination may be justifiable in any event. But with the existing workforce, I think it's probably more problematic to try and introduce mandatory vaccination, particularly where somebody's got 2 years service, because I'm not sure the majority of employers could actually justify that as a fair reason for dismissal, either on SOSR or health and safety grounds. I suspect it would lead to an unfair dismissal claim. So that's it on mandatory vaccinations. Next up, we've got a slide on long COVID. This has come up for quite a few of our clients, actually. Whether or not long COVID is a disability. I think people are probably familiar with long COVID. Effectively, it's where there's signs or symptoms of the coronavirus that have actually continued to occur, or they've developed for more than 12 weeks after the original contraction of coronavirus. And the TUC have quite publicly been campaigning since around June for long COVID to be recognised as a disability, so that workers have got access to some kind of legal protection or compensation in the event of them being dismissed. And the TUC have listed off a variety of symptoms, because the strange thing about long COVID is that if you're unfortunate enough to suffer with it, your symptoms will be very, very different to the next person. And the length of time that you suffer with it will also be very, very different to the next person. But the more common symptoms are fatigue, brain fog, shortness of breath, difficulty concentrating, memory problems, pain-related symptoms, and depression. So they're the most commonly experienced symptoms. I thought the statistic on the slide was really, really worrying. 6.2% of the great British population have said to have suffered with the effects of long COVID. So that's 2 million people in the UK. And I think that number's just going to go up between possibly now and spring, unfortunately. So that's a very scary statistic. And you can see that of those that have contracted it, 30% have said it's negatively affected their work. So a huge number of people are affected by it. But is it a disability or not? That's the question that our clients have been asking us. Well, next slide, please. In relation to whether something is a disability or not, the only person that could give you that decision is the employment tribunal judge, if you're unfortunate enough to be in the laps of the gods and employment tribunal at some point in the future. And what the tribunal will look at is the same law that's always been there in relation to whether somebody has a disability or not, is the definition of a disability under the Equality Act. And there's probably 3 main chunks to this. It's whether somebody has a physical or mental impairment. So that's probably part 1. Do they have a physical or mental impairment? I think all of the symptoms that I reeled off in relation to long COVID probably sufficient to tick that box, that are a physical or a mental impairment. Secondly, does that impairment have a substantial adverse effect on their ability to carry out normal day-to-day activities? Substantial, not a high threshold at all. It means more than minor or trivial. So in the majority of cases, I suspect the second box is ticked. But does that impairment have a long-term adverse effect on the ability to carry out normal day-to-day activities? That's going to be the key question, because for something to be long-term as a disability, it needs to have lasted at least 12 months. And long COVID is unlikely to have lasted that long if you've been in the employment tribunal by now, but it may have done them in a handful of cases. So the secondary question, is it likely to last 12 months or longer? And that's the question that the tribunal judge will have to grapple with. And the only way that he or she can do that will be to look at the medical evidence. So with any case on disability, effectively, we're asking a judge to make a decision based on medical evidence as to whether or not the symptoms are likely to last for 12 months or more. In my view, I think it's a foregone conclusion that there will be cases where people are suffering with long COVID where they absolutely satisfy that definition of disability. It will just be judged on a case-by-case basis, as the majority of these cases tend to be. So in relation to long COVID, just put up a slide as to what should employers do when dealing with long COVID. I think first things first, just be understanding, be fair, be reasonable, and be consistent with the way that you deal, not only with staff who have been suffering with long COVID, but any other staff who are on long-term sickness absence for whatever other reason. And again, on that note, treat people suffering with long COVID as you treat anybody else with a long-term health condition. So you maintain contact with them, keep up good employee relations, let them know what's going on at work, make them feel included, ask if there's anything you can do to assist them, keep them informed of their sick pay entitlements, all the good stuff that you would do in any event. Probably at some point, depending on how long someone's been off, you'd obtain some relevant medical evidence. You'd certainly do that before making any decisions, because without medical evidence, it makes it really difficult to make a meaningful or informed decision about whether somebody can come back. And if so, in what capacity? Do you need to make any adjustments? Do you need to look at other roles? Are they likely to be off for a significantly longer period of time? Very difficult to reach any conclusions without having medical evidence. And secondly, and perhaps more importantly, is that ultimately, if that person can't come back and you do contemplate dismissal, there's a good chance that any dismissal will be unfair and arguably discriminatory if you haven't got that medical evidence in the first place. So really, really important in cases where it's long COVID or any other long-term sickness absence. Whether or not long COVID is a disability, I think it's good advice in relation to employees who are off on long-term sickness absences. If you're in any doubt whatsoever, just assume that the condition is a disability, because then you'll be treating or acting fairly, you'll be acting reasonably, and you stand far less chance of making a mistake. Yes, you'd consider making reasonable adjustments, but whether or not somebody has a disability, I still think any good employer would look at adaptations within the workplace and look at adjustments that could be made before reaching a conclusion that there's no alternative but dismissal, because there are always lots of alternatives that you should consider before you get to the point of dismissal. It should really be the last resort. But ultimately, if you do need to consider dismissal, make sure your reasoning is set out within that meeting clearly. So you've explained the rationale behind the decision, make it clear both in the meeting and in the outcome letter, make it clear you've considered alternatives, and of course, offer the right of appeal. Next up, we've probably got a couple of slides where it's more or less me telling you the headlines of things that are coming into force at some point in the future. So we did have a government consultation launched in April this year in relation to flexible apprenticeships. So it's looking at whether or not certain sectors can offer a more flexible apprenticeship opportunity. And part of the consultation was to look at apprenticeships where certain sectors find it difficult to provide work or provide opportunities because the work that they do is seasonal or doesn't always last for a period of 12 months. So agriculture being one, construction being another, TV, film and production can be a bit more seasonal. So there aren't always opportunities to take on apprentices. So this scheme is all about allowing apprentices to bounce around between roles or bounce around between jobs or even employers so that they can complete their apprenticeship under a flexi-job apprenticeship scheme. The first apprenticeships, I think, will start in January 2022, and there's a £7 million fund that's been put in place to create and test the scheme. And if it works successfully, I'm sure there'll be some more funding from somewhere. Next slide, thank you. So who's moving to Scotland? Anybody with me? Scotland in September successfully trialled the 4-day working week. So this was the Scottish government, as part of the SNP's election manifesto, agreed that staff would go on a 4-day week, pay wouldn't be affected, and they just wanted to see whether that would achieve two things. Firstly, whether productivity would be negatively or positively impacted, or whether it would stay neutral. And secondly, whether well-being would be improved, etc. And the scheme went well, so the Scottish government has now designated a £10 million pilot fund, and it's going to be available for companies that want to explore the benefits and the costs of moving towards a 4-day week. It's been successfully trialled before in Iceland, described as an overwhelming success. I think it was trialled between 2015 and 2019. And it's been so successful that 86% of Iceland's workforce have now moved to either shorter hours for the same pay, or they'll gain the right to be able to do that. It's also worked really well in New Zealand. They've trialled it successfully. So it might be something that could see the light of day in the UK. There is a campaign, the Platform London campaign, Looking for shorter hours, hoping that that might cut the UK's carbon footprint. As we're aiming to be carbon neutral by 2050, it's not completely out of the question. You're not sure what it would mean for employers, because it would mean different things for different businesses. Some might be able to do it quite easily. Others would struggle in terms of the service that they need to provide. Others might be worried that if they go down to a 4-day working week, they don't have the ability to compete with other businesses that still got employees working 5 days or more per week. So I think it's one of these things. Watch this space, but perhaps not in my lifetime. I'd like to think it would, certainly for my children, but perhaps not. Next slide, just a brief update on where we are with a flexible working consultation. This was launched in September this year. It's in relation to a proposal to give all employees the right to request flexible working when they start their new jobs. So the current rules, you're probably aware that employees can apply for flexible working, but only if they have 26 weeks in service. And also, in relation to that request, there's a 3-month time frame within which employers can consider that request. And there are a number of reasons, eight reasons where they could refuse that request. So what the consultation is looking at, firstly, whether or not, rather than waiting 26 weeks, can flexible working or the right to request flexible working be a day one right? I think that's going to be really important. Are the 8 existing business reasons for refusing a request still valid, or do they need to be tweaked or changed? A requirement on employers to suggest alternatives. So if you're going to refuse a request, is there an alternative pattern that might be acceptable to you? And I would say that the majority of employers, certainly clients we deal with, are generally quite keen or quite quick to suggest alternatives rather than just flatly reject a request. So I think it's probably good advice anyway. The consultation is looking at how to speed up the process. I think waiting 3 months is arguably way too long for somebody that is making a request, often in relation to childcare reasons. That might be returning from maternity leave, or it might be when your children go to school for the first time. Waiting 3 months almost makes making additional or different arrangements that little bit more difficult. And how best can the right to request a temporary flexible arrangement be better utilised, because it's not being used very much at the moment. So those things are subject to consultation. And I think there will still be the ability for an employer to deny a request, but I do wonder whether coming out of the pandemic, it's going to be more difficult to deny a request for flexible working, just with the flexibility that we all have now. I'm delivering this from my house. We're all at home doing this. Does that give employees a better rationale for arguing that the flexibility should be granted to them to say work from home particular days or particular hours? So I think it will be harder to reject flexible working requests moving forward anyway. Just a brief update on tipping. So the government has now responded to a consultation on tipping, gratuities, cover and service charges. The consultation unbelievably closed in June 2016, and we've only now had the government response, but the government response has been a positive one. We will see some new legislation. I can't tell you when that will be just yet, but it will come into play at some point. And these new laws are going to help approximately 2 million waiting staff and hospitality workers in the UK. Although it's been estimated that the 5-year delay has cost those waiting staff about £2,000 per year in terms of additional salary. So under the new rules, it's going to be illegal for employers to divert tips and service charges from restaurant workers. Those breaking the rules can be fined, but they can also be taken to tribunal and forced to compensate workers. There's a few bullet points up there in relation to the new legislation. I think perhaps the most important one is that there'll be new rights for workers to allow them to request information relating to the employer's tipping record. And once they've got that information, that will enable them to bring forward a credible claim at an employment tribunal. So it's going to be all about transparency from employers, having a written policy, keeping a written record of how the tips are being dealt with. And if the unscrupulous employers are not doing that, I think there's a real risk of some kind of class action or claims from individual employees. There will be a statutory code of practice brought into play, which will set out how tips should be distributed to ensure fairness and transparency. Finally, before I hand over to Sobia and Hannah for the case law quiz, just a couple of updates in terms of what's on the horizon. I think we have spoken to you about this before, still remain on the horizon, but firstly, an extension in relation to pregnancy protection. in relation to redundancy. So currently, employees at risk of redundancy whilst on maternity or adoption or shared parental leave currently have the right to be offered suitable alternative employment. And the government's proposing to extend that protection. So it should cover pregnant employees as soon as they've told their employer about their pregnancy. It should also cover those returning from maternity or adoption leave within the previous 6 months, and cover parents returning from shared parental leave. So that's the proposal. And finally, proposals in relation to neonatal leave and pay. So the government's proposing to introduce extra statutory leave and pay for all parents of premature babies that need specialist care in a neonatal unit. That will impact on some 40,000 families, because 40,000 children spend more than a week in neonatal care. So the protection will be up to 12 weeks paid leave for parents that are unfortunately in that position, because it's a horrible choice, isn't it, between returning to work and taking care of their newborn in that condition. So again, that will see the light of day, we think, at some point, and we will update you in one of these sessions when we know more. That's it from me. I shall now hand over to Sobia and Hannah for the case law quiz. Thanks.
Thanks, Simon. So it's over to you guys for our case law quiz now. We will be using the poll function, so I'll read out the question and then you'll get a few seconds just to fill in your answer in the poll. So question 1. Just over on the next slide, please. Thank you. So question 1, will redundancy be unfair if no appeal or review procedure is offered? What do we think? Yes or no? Okay, just give you a few more seconds to fill it in. We're getting a lot of yeses through. Okay, and the results that we got, 86% saying yes. So the answer is
Sorry, the next slide.
just over on the next slide.
Oh. Oh.
No. Bit of a surprise answer. So no, not necessarily. This was actually a Court of Appeal decision, and they held that the absence of an appeal is one of many factors that they'll look at overall in determining whether a dismissal was unfair or not. The respondent in this case was a county council who closed one school down and they opened a new school in its place on the same site. All the school staff were told that their existing contracts would come to an end and that they need to apply for new roles at the new school. The claimants in this case were teachers who did interview, but they were unsuccessful and were then made redundant. They then brought claims for unfair dismissal on the basis that, firstly, there'd been no consultation process over the school closure, and also no right of appeal had been offered to them against the redundancy. Their claims were successful at the tribunal and the Employment Appeal Tribunal, and it was found that the council had chosen not to follow the established redundancy procedure. They provided no meaningful or effective consultation with staff, and the failure to allow an appeal was also substantially and procedurally unfair. There were a lot of issues with the procedure, and they found that it had been flawed throughout the whole process and not properly managed. The council, of course, then appealed to the Court of Appeal, but they were unsuccessful. And the Court of Appeal noted that it would have been wrong for the tribunal to find that the dismissal was unfair only because of the lack of the appeal process. But having said that, the tribunal has to take regard to all of the relevant circumstances and look at the bigger picture and see how the process was handled. The Court of Appeal in this case found that the Employment Tribunal hadn't applied a general rule that a lack of appeal automatically makes the dismissal unfair. And they had looked at the overall picture, and the finding of unfair dismissal was upheld in this case. So although this case appears to confirm that the absence of an appeal is not fatal to an employer, as long as the redundancy is otherwise fair and made in accordance with a fair process, I think we should just take that with a pinch of salt. And we'd certainly advise that employees should follow a fair and a complete process, which would include consulting with the employees and also providing them with a right of appeal. Because it's always good to have somebody independent review the process and the decision and really use that appeal process just to deal with any complaints and flush out any issues at that stage. Okay, moving on to the next question, question number 2. Was it an unfair dismissal to make an employee redundant without considering putting them on furlough scheme first? What do we think? Was it unfair to make them redundant without considering putting them on furlough first? Okay, just getting answers. Oh, a bit of a mixed bag. Okay. And the results that we got were? Yeah, so kind of a split, but more leaning towards no. The answer is actually yes. Yeah, in this case, it was. So here, the claimant was a care assistant and she provided live-in care. And in February 2020, the specific person that she was caring for kind of moved into hospital and then onto a care home. So she was no longer needed to provide live-in care for them. In May 2020, her employer warned her that she was at risk of redundancy because due to the COVID restrictions in place at the time, they couldn't offer any more live-in care work. She then asked to be furloughed, but her request was rejected on the basis that there was no work for her. Although they offered her home care work as an alternative, she didn't accept that, and she was eventually made redundant in July 2020 and was unable to successfully appeal against that. She then brought proceedings on the basis that she should have been furloughed instead of being dismissed. In this case, the tribunal found that the claimant was dismissed because of redundancy, and genuinely the respondent didn't have any live-in work to offer her, so that was all okay. But they did note that the coronavirus job retention scheme was implemented to provide support for employers, purely so that they could retain the employees, give them the support and the wages that they need to keep them on, and avoid the need to make redundancies. So this was the exact scenario that the scheme had envisaged when it was launched. And they concluded, therefore, that the employer should have considered furloughing the claimant to see how things changed during the course of the pandemic and whether there would be more work available for her in the future, rather than just dismissing her straight away. And the dismissal was therefore unfair. I think with this case, it's important to note that it's not saying that the employer had to place her on furlough as an alternative to redundancy. It's just saying that it needed to consider it as part of a fair process overall. So with the furlough scheme now at an end, this exact issue might not be as relevant, but I think it's always a good reminder for employers to take into account all the potential alternatives when they are looking to make an employee redundant. Okay, I'll pass you over to Hannah for the next couple of questions.
Thanks, Xavier. So question 3, was it discriminatory to not allow a pregnant worker to return to the workplace during the pandemic? What do we think? Put the poll up for you. We are starting to see a steady stream of claims coming through in respect of the pandemic. Well, most of you are going for no at the minute. Okay, so it seems to be a resounding no, and the answer is no. Well done. So this is the case in which I think the tribunal had an awful lot of sympathy actually for the employer in this instance. The employer, in terms of the employee, the employee found out she was pregnant and she notified her employer right at the beginning of March last year. So in terms of timing, I think she notified them just a couple of days before we went into a lockdown. And so bearing in mind the guidance at the time, which was extremely muddled, there wasn't any real clarity, but certainly there was the view that those who were pregnant should be deemed clinically vulnerable, and therefore the employer took that approach and said, actually, do you know what? We are going to ask you that you remain at home. And so the employee remained at home until May, and in May they decided to allow the employee back. However, bearing in mind she was pregnant, they did say, actually, do you know what, we'll do a risk assessment, and the risk assessment came back that they needed to make sure that in terms of her working in the office, there was sufficient space between her desk and another person's desk, and they also said you're going to need to screen the area off. In addition, the individual ordinarily would go out and meet patients, but here the decision was made off the back of the risk assessment. Actually, it would be far better if you just remain in the workplace, and therefore we won't allow you to go out and travel as part of your role. The employee originally complained and said, actually, I haven't been paid whilst I've been off during this time, and it was decided by the employer, actually she's got a valid point, we will pay her, and they did pay her. However, despite the employee being paid, there was, and the employer admitting that it did take them some time to get the perspex that they needed to put around her desk and to put divides between other desks. The employee said, well, actually, that's not good enough. I believe I should have been able to return to work. This isn't fair. And she went on to pursue a claim for pregnancy and maternity discrimination, and asserting that she was treated less favourably by reason of her pregnancy or maternity. In this case, the tribunal sided with the employer, and they said, actually, we don't believe you have been treated less favourably because of your pregnancy. And we've looked at this. The employer followed the government guidance at the time, and therefore advised that you should stay at home. The employer went on to do risk assessments and followed those risk assessments and the directions given in those risk assessments, and off the back of that, that's what meant you were unable to return to work. But in these circumstances, the tribunal certainly said, we don't believe you've been treated less favourably because of your pregnancy, and the claimant was not successful in this claim. I think the point to note on this claim in particular is that the employer was able to justify its position very clearly. It had its records, it had kept the government guidance, so that was available and could demonstrate what it was following. It also had copies of the risk assessments and could explain very clearly what their risk assessments findings were and why they took the approach that they did. And certainly from the employer's perspective, they said, look, we are trying to do our level best for the employee here and protect the employee in the best, and the only way we can do that is to comply with our risk assessments. So I think in this case it was absolutely the right decision in these circumstances. Final question. Is HR advice about a potential dismissal admissible in employment tribunal proceedings? What do we think? So is HR advice about a potential dismissal admissible in employment tribunal proceedings? Oh, most of you are going for yes at the moment, which makes sense. I understand how you reach that decision. A couple more seconds. The findings are, you've gone for yes, and the answer is no. This case comes with a health warning, okay? I will tell you the background to the case, but it is very specific. Essentially, this case is about privilege. And you may have heard the term privilege used in the context of legal privilege. Legal privilege is where there is communication between a client and a lawyer. And because, and it's very often the client saying, I need some advice, the solicitor is providing that advice. And that information and that communication is deemed privileged, and therefore it's not disclosable. It's got a special exemption applied to it. There is another type of privilege, and that's called litigation privilege. And litigation privilege is, again, advice sent from perhaps a third party, i.e. an HR consultant, to their client, giving them advice. But to attract litigation privilege, it has to be, the circumstances have to be that there is litigation in place, i.e. there is litigation existing, or alternatively, litigation is in contemplation. So you could find yourself in a situation whereby an employer emails a lawyer and the lawyer provides advice, and that email communication, or that communication in general, is privileged, so it won't be disclosable in employment tribunal proceedings. That same email sent to an HR consultant, unless there is litigation in existence or litigation is in contemplation, that same email is completely disclosable. So there's a marked difference between legal privilege and litigation privilege. However, in circumstances where in that email communication there is essentially the purpose of that email is for fraud, or there's some kind of criminal activity within that email, there's an exemption. And that means that under the exemption, which is the iniquity principle, that email would have to be disclosed. So you can't hide behind privilege in circumstances where there's fraud or criminal activity within that communication. And that's what this case was about. So what happened was Mr. Hart was dismissed by reason of gross misconduct, and he went on to pursue a claim of unfair dismissal. Before he got to the tribunal, he made a subject data access request. And as part of that, the person who dealt with that unfortunately disclosed a lot of material to Mr. Hart that he shouldn't really have had, because it all contained advice in terms of the proceedings that needed to be followed in terms of the disciplinary process. And there's also advice in respect of the dismissal itself. As part of the tribunal proceedings, and in any proceedings, both parties, so the claimant and the respondent, have to go through a disclosure process. And that means you've got to disclose documents which are both good and bad to your case. However, you don't have to disclose documents which are subject to privilege. And in this case, Abbeyfield said, well, actually, we've got a number of emails, but they're all subject to privilege, so we're not going to give them to Mr. Hart. Mr. Hart said, well, hang on a minute, I don't agree. I believe that there are some emails there that you should disclose and are not truly subject to litigation privilege. And fundamentally, it rested on one email. And in this one email, one of the managers of Abbeyfield had sent an email to an HR consultant seeking advice. And in that email, the manager had said, the claimant's rudeness and gross insubordination has caused major problems, and this cannot be allowed to continue. He will not, therefore, be returning under any circumstances. So what Mr. Hart was saying is, actually, that email was sent months before I was dismissed. Therefore, that email in itself shows that this process was an absolute sham in terms of going through a disciplinary, in terms of going through an appeal process, because the outcome was always going to be the same. I've got an email that shows the manager wanted me out. And he was saying, it's not fair. The Abbeyfield cannot hide behind privilege, litigation privilege, and they should have to disclose that email, because I believe the principle of iniquity kicks in at this point, and therefore privilege shouldn't be used in this particular example. The tribunal considered this, and at first instance said the employment tribunal actually sided with Mr. Hart and said the document was disclosable. However, Abbeyfield appealed, and on appeal the tribunal looked at it and said, actually no, do you know what, we've looked at the content of that particular email. We don't believe there's any criminal activity or fraudulent activity in that email. All that is happening is the manager is saying, I don't believe the employee should return to work. And in reply, the HR consultant said, actually, right, okay, this is the process you need to follow. And they set it out. So what the tribunal did was actually look at the substance of the email itself in terms of what it was actually saying. And on that basis, the tribunal said, actually, it's not a disclosable, it's certainly not disclosable, and actually we think it's protected under litigation privilege, and therefore it wasn't disclosed as part of the proceedings. as I said, in terms of the health warning that comes with this case, I don't think this case should be the case that everyone relies on in terms of saying, well, actually, it's okay what we put in an email to an HR consultant because it will be subject to litigation privilege. That is not what this case was saying. I think in this case, actually, Abbeyfield were very lucky that the tribunal sided with them in terms of the appeal by saying, actually, we think it fell under the litigation privilege because litigation was contemplated at that particular time. I think that might be a bit of a stretch in reality, but I think it's certainly something to be aware of in terms of thinking, actually, when your clients are emailing you, is that email subject to privilege? Can we rely on privilege in the event that there is an employment tribunal? I think the other point to take on board is that had the person dealing with the subject access request done it properly and actually realised that some of the documents that they subsequently disclosed didn't need to be disclosed, we wouldn't have had this argument within the tribunal. So again, I think it's really important that when you are dealing with a data subject access request, that the person dealing with it actually spends the time, and I know it can be absolutely time consuming, looking at the documents and being absolutely confident that the material it is disclosing is actually disclosable material. Because as I say, in this case, the situation could have been avoided in its entirety. Okay, that brings our case law quiz to an end and also brings our seminar to an end. If you've got any queries or questions, I'm not sure that we've got any on the chat box or in the Q&A section. I think everything has all been answered, but thank you ever so much for joining us. We hope we found that really useful and we look forward to hopefully seeing you in person again soon.
And just on behalf of all the members who I know you can't see, I'm going to give you a virtual clap. Thank you very much, and hopefully see everybody soon.